Okay. I think
There appears to be something wrong with my camera, and I don't know what. I'm a gray blob.
all right. All right. So good morning, everybody. This is Judge Evans. We're here in the Mandy Graunitz and Nathan Bopp here today for a partial motion for a partial summary judgment. We have present Ms. Winkles, and I see Mr. Bopp is present. Mr. Bopp, can you hear me okay? Okay, great. So noticeably absent, at least currently, is Ms. Graunitz. And just double checking to see if any of the parties or any folks on the line have heard from Ms. Graunitz to check status where she's at.
I think she did email me this morning. I haven't seen it. Let's see. I think I saw it right before we got here.
Okay.
Let's see, does she say anything? She's arguing about who the cats belong to. And then that appears to be all. She doesn't say anything about today's hearing.
Okay. All right. So it looks like the parties gathered on the 12th of December for the trial readiness hearing. And that was an indication that it was set for today, December 18th, 9 o'clock in the morning. I think probably what we should probably do is just take a brief recess, give her an opportunity. If she has any difficulties with Zoom, then she could sort those out, and hopefully she can be here. So if you're agreeable to that, or if you have any concerns with that, I'd certainly hear from you. But I'm proposing to come back in about 10 minutes, a quarter after the hour, and just see where we're at and see if she's made it into the Zoom.
That works for me, and I can see what's wrong with my camera. Thank you.
All right, very good. We'll reconvene in 10:08. We're here today for a motion for partial summary judgment. See, Ms. Winkles is here, camera working properly. Mr. Bopp is here also, and I'm making an assumption on the phone call. We have Ms. Mandy Graunitz. Ms. Graunitz, can you hear me okay?
Yes, Your Honor, this is Mandy Graunitz. Can you hear me?
Yes, and what do you prefer to be called? I heard your last name, and I may have misheard it. Can you state your last name again?
It's Graunitz.
Good.
There's no easy pronunciation.
Okay. All right. Great. All right. So we are.
Sorry, who's the judge? Who am I speaking with?
Pardon me. This is Judge Evans.
Evans. Okay. Thank you.
Oh, you're welcome. All right. So in preparation for today's hearing, I reviewed the motion for summary judgment filed by Mr. Bopp via Ms. Winkles and the attached exhibits. I also took a look at some sealed financial records that were submitted by Mr. Bopp. In addition, let me just pinpoint it here. There is a response filed by Ms. Graunitz on November 20th. Response to respondent's motion for summary judgment and memorandum of law. So those are the two documents that I reviewed in particular for today's hearing. I've reviewed them previously, and then I've reviewed the case file. So just want to make sure if there's other documents that I should have reviewed, but that I missed, or I'll start with you, Ms. Winkles, as the moving party.
Yes, Your Honor. We have no additional documents. I believe everything is stated. It's a very small motion for summary judgment. It's very much a partial motion, just on the things prior to the relationship. From reading Ms. Graunitz's response, it looks like she doesn't contest the date they got together, the date they moved in together. And it looks like she doesn't contest the dates he purchased those assets that he's claiming were purchased prior to the relationship. I believe the only one that seems to be an issue is the boathouse on the date he purchased that, and the home, any improvement in value, but not the actual underlying asset. So I won't go too much into detail since Ms. Graunitz is pro se, since Your Honor has also read the pleadings. I'll leave it at that. And we just ask that you grant her motion.
Okay. Thank you. Ms. Graunitz, you heard me rehearse the documents that I reviewed in particular for today's hearing. Are there any documents that were submitted that I had missed that you had hoped that I had reviewed?
My apologies, Your Honor. I have been unable to submit further documents. I have other declarations and other things to submit. However, I don't think we're very far apart on this today, so I am able to carry forward without those submissions.
Okay, all right, thank you. And let me just double check with Ms. Winkles indicated that there's some potential agreement between the parties related to some of the contested facts. And let me just review those with you, if I could, Ms. Graunitz. There's a allegation that the committed intimate relationship started in mid 2018. Do you agree with that or not?
Yes.
Okay.
Agreed.
Okay. And then as far as the drive in Longview that's alleged to, that home was purchased by Mr. Bopp in November of 2013.
I would take his word on that. I wasn't there.
Sure. Okay.
But
sure.
He lived in the home prior to me moving in. So.
Okay. All right. Thank you. And then as far as the end of the committed intimate relationship, let me make sure I understand Ms. Winkle's position. I think the position, Mr. Bopp, is summer of 2022, and then there was a definitive end when the no contact order was entered in May of 2023.
That's correct.
Okay. And Ms. Graunitz, what's your take on that? Are you in agreement with that, or do you differ?
My understanding as a participant in the relationship was that we did run into some contestation in June. The end of the committed intimate relationship in my position is February of 2023. We were still cohabitating through May of 2023, but we were friends in a friendship relationship over a romantic relationship, March and April. However, we were still sharing the same bedroom. So in April, we both mutually agreed the relationship was non-repairable. That is the dates I have discovery to prove. So by May of 2023, we have had no contact. So obviously we've been severed since May, but we were still amicable up until April 15th.
Okay. All right. Any concerns with that, Ms. Winkles?
And we're fine with that, considering that, anything before that we could argue at trial, but at least we agree that it definitely was over by that point.
Okay. And then as far as the boathouse, there's an indication that Mr. Bopp purchased the boathouse in September of 2017. Ms. Graunitz, what's your take on that? Do you differ or agree?
I'd like to blanket cover the assets on this, and then if you have other questions, you can ask me specifically. What assets Mr. Bopp had prior to the relationship were the boathouse, the boat trailer, the Park View Drive residence, the expedition, and the small utility trailer. Those are the assets I moved in with Mr. Bopp, with him having. Now he had just purchased a bunch, I think the boathouse and the boat. So he had like a $60,000 something loan value associated with those assets at about like a 7 to 15% interest rate. And I think his monthly payments were somewhere $750,000 or something for non-household payments. In 18 to 20, we purchased a house, a little trailer together, remodeled it, sold it, and at that time the interest rates dropped. So I talked with Mr. Bopp about refinancing all the assets into the home loan, and it took the home loan from $1,000 and the other assets, $1,000 in payments, or $2,000 in payments for all assets prior to the loan at whatever interest he was paying. And after the loan, all of those assets were incorporated into the house loan at $1,500 at a 4% interest rate. So we saved like $1,000 or better a month in payments and interest. That is the reasoning for the CIR. We cohabitated, we worked on a house together, we recollected and refinanced with the intention of rebuilding a life together. All of that said, I have no specific interest in any of Bob's assets. I am not looking to threaten his ownership on any of his assets. The assets he has, I helped him build, I want him to maintain. Whatever interest I have in Parkview, I need to calculate. But my interest in Parkview, I will donate to Chloe because she is the reason I built up Parkview. She wanted a nice home. I built Chloe a nice home. I want Chloe to stay in the home I built her. I don't want to threaten the boat or the boathouse. Those are Mr. Bob's. They're his personal things. They're sentimental to him. At the end of this relationship, I will own nothing from Mr. Bob because my intention is to return whatever was from the relationship back to him. I'm starting over fresh with nothing from either relationship. So I do not want Mr. Bob's assets. I don't want to threaten Mr. Bob's assets. However, I do have a legitimate claim in the work I did on the house, and I still have to calculate what that looks like for my spreadsheets, for my future business projections. At this point, I just have to recapture the thousands of dollars I just lost and show investors I'm able to produce a product for my future business. That's where I'm at in this. My whole issue pending on this whole case is what we do about my tax reporting from 2022 and 2023. I have 12 days to figure out what to report to the IRS about my income. And that's where this is cloudy, because if he wants to say that CIR ended in June of 2022, I have to go back and recalculate what the rates look like as a contractor, not as a homeowner. Either way, all of this leads to I was a contractor resident on site. We had a relationship. I'm willing to walk away from the relationship. I have to figure out how to walk away from the business element. So I need to capture what that looks like in money. I've dispersed my discovery so I can get help going through all the pictures and messages and getting them organized in a fashion to put in together a 5-year time sheet. I have to separate my client jobs from Parkview jobs, from relationship time and parenting time, general household maintenance versus specific contracted maintenance that he would have had to hire out. So I have a lot of time separation to do. I'm doing it specifically for the audience of my business reporting. I'm hoping not to have to submit this information to the IRS, but I need proactive resolve on Mr. Bob's end because I'm left with a huge financial deficit I have no way to cover. And if I don't have the funds to report to match the 1099 that I submitted and been reported, that creates a problem for my business and for the IRS and for all the reports. And then the IRS has to go snooping through Bob's business accounts, and then that red flags his job. And I'm trying not to red flag his job because he needs his job to pay for this house I just built him. So I would really like counsel and her client to figure out what to do about this 1099 issue, and any and all assets that I have of Mr. Box, I'm willing to give back to him or let him claim ownership of or have, because I don't want anything remaining from that relationship in my next venture of life. I don't need any of the assets. I need paid for the work I did, and I need to catch up on my timesheet to submit, and I got 12 days to get it together. So I've hired a crew. We did a sweep of Mr. Bob's assets. Sorry.
No, I apologize for interrupting. We were just doing some preliminary checking to see if there's agreement as to facts, and we were talking about the boathouse. You agree that Mr. Bob acquired that prior to the relationship, and the Parkview home was acquired prior to the relationship starting, and that the relationship started mid-2018 and ended April 2023. I think those are the facts that generally the parties are agreeing on. Do you?
Yes.
Okay. All right. Just want to make sure we're clear on that. So with those preliminary issues addressed, I'd like to give each party an opportunity to argue your particular points of view related to the motion for partial summary judgment. So in order to facilitate that, I'd encourage welcome Ms. Winkles to go first, and then welcome Ms. Graunitz to go thereafter. So Ms. Winkles, will turn the time to you.
Yes, Your Honor, just a couple of quick statements. Because we agree on those facts, and because what is being argued here is a CIR, not a marriage, that means that separate property is not on the table. There's case law that backs that up. The court wanted to distinguish that between a union that is a marriage and something that is akin to marriage, but they aren't the same thing. And the reason that they're not the same thing is one is thought out, one is binding, one is contractual, the other is essentially an agreement to live together. And it's just happens to be what comes up over time. These parties argue about whether or not there was a CIR, but what they don't argue about was the date their relationship started and the date their relationship ended. Because it's a CIR, certain things such as attorney fees are not on the table. Other separate properties not on the table, and spousal maintenance is not on the table. Those are things that are reserved only for people that get married. So it should be a really simple way of picking which property is included. Anything that was purchased by either party prior to June of 2018 or after April of 2023 is not on the table. And that is all we're here for today. And my client has put a list together of all the property that he purchased and the date that he purchased that property. And that was attached on his motion for partial summary judgment. It was attached as one of the exhibits. And of course, my computer froze. So I was about to go there. He's attached pictures of the year he purchased it. And in that financial data, we've also received our subpoena back from Home Depot, which shows when he's purchased a lot of that. It doesn't appear that there's an argument on when he's purchased that. I didn't see anything in Ms. Graunitz's response contesting any of those dates. Anything that's obviously from mid-2018 to April of 2023 of that exhibit would still be on the table. But anything outside of that should be considered my client's property, and it should not be a part of the CIR. And the same for Ms. Graunitz. Anything that she purchased prior to that time or after the date of separation would be separate property and not a valid part of the CIR.
Thank you. And then to help me understand your position on this. So if I understand your argument correctly, is that everything that was purchased prior to June of 2018 and purchased or acquired after April of 2023 is separate property of either party. And so in specific to Mr. Bopp, there's the Exhibit F of your motion for summary judgment gives the listing of the different properties that were acquired, and also the Parkview home, the boathouse are also included within that property that's alleged to be separate property. And so since that's separate property, then is your argument, does it preclude Ms. Graunitz from making a claim of basically contribution to the separate property and an enhanced value? And how do we handle that?
So no, so this is just on the actual value of the asset. So essentially the house is separate property, but any improvement on the house that was made during the period of cohabitation, if Ms. Graunitz can later prove that she put money in and time and whatever, that is different than the asset itself. That's the change in market value. Obviously, the reason why I say it's different from the asset itself is any change, just given the nature of the asset, for inflation, for market changes, that stays separate. So the only thing that changes is any change that they made during that time period together, if they had a CIR. So when I say that all of the personal property is different, though, when I say the personal property in Exhibit F, there's no improvements on those. You're not going to improve a lawnmower that you buy new. You're not going to improve a gun that you buy. Those are a given. The boathouse and the property, the underlying asset would be separate property. And that would be the same in a divorce. What you buy beforehand remains. It doesn't change its nature. It doesn't change its character because you get married. It stays what it was the date you bought it. So that would be separate property. essentially there would be a reservation on whether any change in value would be attributed to a CIR or to community. That makes sense.
Thank you for clarifying that. Okay, Ms. Graunitz, would you like to share your position, please?
My argument for the CIR, and ultimately the reason I invested so much, I took my entire year off of client jobs last year and worked solely on Parkview. After Mr. Bopp drafted the will assigning 1/3 ownership to me of the residence, assigning me the truck, assigning me a whole list of assets, November of 2021. We refinanced the house and then learned that if something happened to Mr. Bopp, remember this was during COVID, he had major medical issues and we were doing a lot of health care for him in 2001 during COVID. So if something happened to him at that time, the house would not go to me. So we drafted a will together where if something happened to Mr. Bopp, I had ownership, 1/3 ownership, Chloe had 1/3 ownership, Jeff's mom had 1/3 ownership. And what that did for me mentally was it solidified our relationship and it gave me empowerment to make improvements at Parkview, knowing that I had 12 months to relocate if something happened. So I had enough of a time buffer to build a new house. Any and all improvements ever made at Parkview were always for resale. It was never for us to live there permanently. So last year, Chloe and I made her a room. We made the kids' rooms. I did a bunch of improvements last year. So in my head, and according to this will, and up until June 5th of 2023, I was in position to take ownership of the house, maximize its value, sell off the house, reclaim 1/3, and then give whatever increased value to Chloe and Jeff's mom. That was where I was.
And that's if Mr. Bopp were to pass away under the will, action of the will, correct?
Right. Now, obviously our relationship ended, and so now I just have to go back and figure out my value in the relationship as either what did I change the value of for market value of the house, or what would I have charged as contractor pricing for the work I did. And I'll make both comparables because it's just a couple of, so that's on the tracking of the time in the spreadsheet. So that looks to be the next issue I would like us to deal with, but that's not on the table for today because today we're just talking about separate assets. So they're wanting to claim ownership over the specific assets. I'm not wanting to argue that he should maintain ownership without relinquishing the right to say at one point I did have an ownership right. I'm willing to walk away from my ownership rights. I just need to figure out what that looks like in the numbers. He can claim all the assets and pay me however he wants to. I don't want to jeopardize the house or the boathouse or any of his assets for him to pay me. We just have to figure out what he's paying me, and then he can figure out how to get the money. So,
so let me ask you specifically, if I may, Ms. Graunitz, with regard to that,
yeah, go ahead.
in related to the Exhibit F of Mr. Bopp's motion for partial summary judgment, it gives a listing of different property items. And I think you said, and I just want to confirm this, I think you said that you don't want to divest or take those items of property away from Mr. Bopp, and you agree that he should keep those. Is that accurate?
Okay, hold on. Yeah, so this list is a major thorn. When Bopp and I separated, we were in the middle of a home remodel project. So if you can just envision in your head for a second, have you ever seen the remodeling shows on TV? Where the designer comes in, they speak with the client, they come up with a plan, the client moves out of the house, the contractor takes over, they improve the house, then they restage the house for the client. That's my profession. That's what I do regularly for the last 20 years. So we were intended to update the entire first floor of the house. And we were under construction. I had boxed up everything, well, a good 2/3 of the house in March. The living room, den, and hallway. So in this time period, Bob and I agreed to separate, and I agreed to move out. Then we had some issues with the job. So May 10th, I had loaded up an entire trailer full of job site tools and stuff to start a different job. I do my job in pulses. So when Mr. Bob was away, I had a bunch of people come in. We did a bunch of work. When he and his daughter were around, I scheduled people to work somewhere else so they could have the house. There was supposed to be a lull of time between May 19th and May 19th and May 31st for us to go back and do a huge push on the house. But we were running into job site conditions. In order to work on the floors, I have to strip everything out of the space, and then everything has to go somewhere. So it goes into storage, and doors, the elements that need processed go into the processing center. So I have a storage unit, I have a processing center. Doors, trim, things that need painted go in the processing trimmer, and they can get processed off-site while I work at the customer's house. That means I don't have to be at the customer's house that much, and I have a place to do my work. That's what Mount Brinion is. So there's a huge list of items here stuck in Mount Brinion. They got put in storage. There's sentimental personal stuff that was put in storage, and then there's tools that are separate. And then there's a bunch of, anyway. Back to the point, I made a returns list, and I have people on the quest for these items. I don't know what items are even, I don't even know where these items are. But there is a quest for these items, and whatever items are on the list are intended to go back to Mr. Bob. We went through, we did a huge search this weekend, found some sentimental pictures, and cookie jar, plate, some sentimental property. So I'm on a huge quest to get Mr. Bob's sentimental property back to him. I don't want liability of it. His stuff got stored in May. I had my family sell their house. My mom and brother and sister all lived in a house in Lewis County with a 6,000 square foot barn, and it all got vacated. Part of it came to Mount Brinion. Then Mr. Bob and my kids' stuff. So, what was ask the specific question again, and I'll give you the specific answer.
Yeah, I appreciate the explanation. So on Exhibit F, there's a list of different property items, tools principally, that Mr. Graunitz submitted. Shows dates of purchase, and he's indicating that those are his items, that he had them prior to the relationship, and he just wants to have possession of those. So I guess my question is, do you agree with that? Or do you disagree with that?
I'm trying to look at the list.
There's only a few in there that I saw were post 2022. There's a couple that were, like, there was a trail cam and purchased allegedly in 2023. Other than that, everything predates that, 2012, 2008, 2022. There was a couple things in 2022 that were purchased. One thing in 2020 from Harbor Freight. Other than that, everything else seems purchased before 2018 or after April 2023.
So when you look at your list, is the first picture the nail gun?
So let's see. So I'm looking at Exhibit F, and I'm looking at the DeWalt nail gun purchased 2016.
Yeah, okay. Okay. I don't know when he purchased that. We've been using that together. We used it on the trailer. We've been using it together. He can have it back. I don't know where it's at. The weed eater should have back in his return
Ms. Graunitz,
custody.
we're not going to go one by one on each of these items. I apologize. We're not going to do that. But what I want to know is, his position is that those are his items that he brought, that he either purchased prior to the committed intimate relationship or post-committed intimate relationship. Do you agree with that or disagree with that?
This list is a mixture of pre and post. So I don't know how to agree with it. I can't agree with the list.
Okay. And then
the sentimental stuff,
disagreement with that. So your disagreement with that. I wanted to know if you put. Hold on. I want to know if you put any of that disagreement in writing, like specific items that you say you disagree that those should go to Mr. Bob, or that they should not go to Mr. Bob, better said.
I do not believe it has been submitted to court. What I am contesting is about ownership. I haven't yet even determined what I am contesting about ownership. I'm just trying to find if these items even exist in my possession. So,
and to clarify, it sounded like you said earlier that if you don't contest Mr. Bob retaining possession of those items or obtaining possession of those items, is that accurate or not accurate?
The only items on the list that I am contesting ownership of would be a handful of the tools. Otherwise, any items that ever belong to Mr. Bob are scheduled to get returned to Mr. Bob, whether they're on the list or not. So there's stuff on the stuff that I might have that's not on this list, and it's going to go back too. So I'm not trying to argue that he should have any of this stuff or get any of this stuff back. I can put in writing a handful of things that would be contested, and those would be during our duration of period of time together that we purchased those together, or we purchased a replacement item for something that broke. I haven't looked at the receipts yet, but I do have them.
Okay.
But really, I think he just wants his stuff back, and I want him to have his stuff back. And so, we're not contesting him getting his stuff back. Right now I'm kind of in a holdup. I've given him as much back as I can find. I have to do another round of scheduling to move all the stuff in the way to get the rest of his stuff. And then after I go through and do a thorough search of the properties, then he can contest what's missing. Because I can't say, I don't know if he purchased these at these times if I wasn't there, you know? I can attest to what we purchased together, and I can make that list.
Okay. All right. Thank you. All right. So
bear with me. May have made this too big.
Ms. Winkles, anything in rebuttal?
Yes, Your Honor. The time for responding, the time for putting that in, the court has already passed. Motion for summary judgment, motions for partial summary judgment are court rules. They're written in such a way that anybody can understand them, be it an attorney or be it a lay person. It clearly states, we have to file the motion 28 days ahead of time, 11 court days before it's heard, or calendar days. I can't remember off the top of my head. She responds, and we have an additional 5 days. Had she put in a response, we would have put something else in, but it looked like at that point, and we've been continued, she was allowed to have more time to submit things. It looked like we were in agreement. If we weren't in agreement, there was a question of fact that we probably wouldn't be here today. But it appeared that we had agreed on all of these items. It appeared when she first started talking that we agreed. As she continued, it sounded like there were some items, but not all items, that she didn't agree on, but she didn't point those out. The fact is that the rules are the rules, be it for attorney or lay person. She's been given multiple opportunities to do this, even in discovery. She hasn't done it. We'd ask that you grant our motion. It's appropriate because there's nothing before your honor that contests anything. There's no question of fact before your honor.
Thank you. And Ms. Graunitz, I'll just give you just a last word. So if you have any additional items you'd like to raise in response to the motion for partial summary judgment, I'd please hear from you now.
I do apologize. I feel unprepared on what is it they're asking here.
Yeah, what Mr. Bopp is asking for, from my understanding, is he's asking for a judgment indicating that there was a committed intimate relationship from June of 2018 to April of 2023.
Oh, Your Honor, that actually is still contested, the committed intimate relationship part, but just that there was a relationship during that time, we're not contesting.
Okay.
The committed intimate part of it we are, but that would be for a trial.
Okay. So they're asking for that the separate property, that the boathouse be declared separate property and the Parkview Drive home be declared separate property of Mr. Bopp. So I think that's the extent of what Mr. Bopp is asking through his motion.
Well, unless they're willing to commit or agree that it was a committed intimate relationship during that period, then I can't. Sorry. How do I even report or capture this in? For 5 years.
I think what they're saying is that there's some parentheses or some bracketed time where there's no possibility of a committed. So hold on, that there's no possibility of a committed intimate relationship occurring prior to mid 2018 and post April 2023. I think that's their position. They're saying that section of time is carved out. And any time before that or after that, there's no possibility that there's a committed intimate relationship beyond those bracketed periods. If that helps.
Okay. That is agreeable. So I can calculate my time both as committed intimate relationship and as what the live-in person who did work on the house. Or how do I
so yeah,
report who
the procedural stance in which we're here today is there's a motion for partial summary judgment. What it basically means is that the party bringing the motion, Mr. Bopp, says there is no genuine issue of material fact that the boathouse and the Parkview Lane home are the separate property of Mr. Bopp. That's what they're asking for today. Issues such as your contribution to the home and its potential increase in value, that is a separate matter. It's not being decided today. So that's kind of their argument. That's what they're seeking today, is that an order that says, look, there's really no contest to this. There's really no facts to figure out that the home and the boathouse are separate property of Mr. Bopp. So if you, Ms. Winkles.
Yes, and those items on Exhibit F that were purchased prior to 2018.
Right. So those are the three issues that we're dealing with now. So if you have any rebuttal to that, I'd be happy to hear you.
I am agreeable to quieting the title on the properties, the boathouse, the boat, and the Parkview Drive.
Okay.
The tool assets are under contestation. Those were part of, if it wasn't a CIR, then it was a property development relationship. I need that identified today or by the year's end for my taxes. So that may not be their issue, but I need to know if they're not agreeable that we were a CIR, then I need to know what am I reporting myself at in 12 days? Because we bought a lot of stuff together in the last 5 years. So there's this list of items that he submitted, and it was part of the relationship. even stuff that he bought prior to, the whole relationship was, everything was ours. So the list of tools that specifically everything hasn't been returned, most of this stuff has been returned except for some settlement. Anyway.
Okay. All right.
So the judgment needs to come with either we were a CIR or how I report myself in 12 days. But he can have the assets back. What he doesn't have back by now, he'll have either before Christmas or New Year's. So if you want to award him judgment on that, it's I'm coming from a business perspective, and I'm trying to translate into a legal position, and I'm jammed either way. I just need to know what we're doing about our income situation, and that kind of affects the CIR situation. So yeah, I guess there is a question. So I don't have interest on the asset list beyond any of some of the tools that we've used and are acquired together the last 5 years. So I can separate the list, or they do the whole list. I would contest the list in general because he has back the things that I won't contest, and he's scheduled to get back anything I wouldn't contest. So I am disagreeable on the list because I'm willingly giving those back anyway. You don't have to make a judgment on those to begin with. But the boathouse and the you can quiet the title. I'm agreeable about that.
Okay. Thank you, Ms. Graunitz. I appreciate that input. And just one final item, Ms. Winkles, I just want to ask you, your position related to property acquired during the alleged committed intimate relationship, is that divisible?
If there is a committed intimate relationship, it would be. Anything 2018 and on, but nothing before that would ever be divisible because it remains separate property. But again, we're contesting the CIR, but it doesn't matter anyway for the purposes of that would be determined at trial, I'd imagine. And those items, whether or not they're community property or whether or not they're the party's separate property, I think the CIR has to come first on that issue.
Okay. All right. Thank you. All right. So I'm ready to give you my decision. I think here that there is no genuine issue of material fact that the boathouse and the Parkview Drive, the 2829 Drive, Parkview Lane, are separate property of Mr. Bob. The boathouse was acquired September of 2017. The Parkview Lane or Parkview Drive address was purchased in November of 2013. That's when he took title to the home. So I'll grant the motion for partial summary judgment that those are the separate property of Mr. Bob. Regarding Exhibit F, I'm not making a finding of committed intimate relationship during kind of the general timeframes everybody's talking about, the April 2023 being the end point, the start point being June of 2018. But there's general consensus and agreement between the parties that is generally the time of the committed intimate relationship. So therefore that puts with it Exhibit F. What I see there is I have this averment or a statement by Mr. Bopp and says, hey, these are tools that I purchased in these particular years. And they have dates ranging from, I think, 2008 up to 2023. So what we know when we take a look at that bracketed period of dates, the June of 2018 to April of 2023, that's at question. That's the potential committed intimate relationship period. If we know that a tool or a piece of property was purchased prior to June of 2018 or post April 2023, it's not going to be in consideration for a potential committed intimate relationship type of division of that property if it were purchased during a time of the CIR. So any property that's on Exhibit F, well, let me back up a little bit. There's no specific averment from Ms. Graunitz related to those pieces of property that Mr. Bopp laid out in his exhibit. It's fairly clear. It was filed back in September of 2023. And there's been not an averment or a declaration or affidavit of Ms. Graunitz saying, hey, no, actually that one should not go to Mr. Bob. So I think where I come down on that is any property that's outside of the bracketed period or bracketed dates is Mr. Bob's property. So anything that's in the contested area of June of 2018 to April of 2023, if it's within that bracketed period, then it's still undetermined what the status of that property is. But anything outside, either before the June 2018 or after the April 2023, it vests with Mr. Bob. So that's my ruling. So we need to take a look at a date for presentation and then also address any points of clarification related to the ruling. So let's take that up first. Any questions related to the ruling?
Not from our side, Your Honor.
Okay, Ms. Graunitz.
Yes, I have just a couple quick questions. I did a quick scan of the items and of what's not been returned and things that were purchased pre-18 was the lawnmower. Mr. Wheeler mentioned Bob gifted him the mower. If that's true, then could parties put in paperwork about that, or does he want the mower back, the push mower? He got the riding lawnmower back. And then there was a question about the barbecue. And then it looks like nail guns, sanders, and grinders and grills. And so I'll put that on my list for the next thing for him to get back. And then whatever else remaining in that period will be under contestation. Is that what I'm hearing?
So I'm not making a detailed list of the specific property items. I'll allow the parties to look at that and make determinations from my ruling. But any property that was acquired prior to June 2018 or post April 2023 is the property of Mr. Bob. So that I stick that in kind of just those general terms, and I'll allow the parties to kind of work out the specifics. So with that clarified, let's take a quick look at a potential date for presentation. And again, a presentation hearing would be Ms. Winkles as representing the prevailing party on the partial motion for summary judgment. She would prepare a proposed order summarizing what the court ordered here today. She would draft that. She would submit a copy to Ms. Graunitz for your review. And then we would come here on a particular date. And if there's any disagreement, then you would ideally, you would file that, say, hey, the judge said this, but Ms. Winkles is saying this, and she's got it wrong. So therefore, I'm objecting to it. But if Ms. Winkle gets it all right, basically, she summarizes correctly what the court ordered, then you could sign off on it, and we could strike the hearing. But if you have any concerns about the order, we would have that hearing so you could air those concerns. So I do those generally on Friday mornings at 8:45. So I'll take a look at the parties' schedules. I know we're getting close to the holiday season, so that kind of tends to slow things down, not necessarily, but Fridays are the date we're looking at. So I'll hear from Ms. Winkles if you have a proposed date.
I'm already on Friday the 22nd, so that's fine for me. The 29th, again, fine for me. Pretty much any Friday I'm here. So whatever works for Ms. Graunitz works for me.
And Ms. Winkles, do you think as far as a proposed order that could be prepared and distributed fairly quickly?
Yes, I can get that done today.
Okay. So let's take a look then at so the 22nd, I have two presentations that are currently on. I'm just pulling them up. I think one involves, yes, Ms. Winkles on the guardianship matter. And then I have another presentation. So I think we should probably steer away from the 22nd because they only give me 15 minutes and I've got a trial that same day also. So the 29th is doable. Ms. Winkles, would that work for you?
And that's fine with me. Yeah, I think the trial is with me actually as well. You might get sick of me on the 22nd anyway. So let's do the 29th works. Okay.
Ms. Graunitz, does December 29th, Friday, 8:45 in the morning, is that an agreeable date or does that work for you?
Yes, Your Honor. What's my response date?
Yeah, if Ms. Winkles submits the proposed order to you today or tomorrow, I would need to see something prior to the 27th. So 27th to be the cutoff date and to give both objections to Ms. Winkles and to the court. Okay. So,
And I'll have that forward to him.
oh, sorry, go ahead. The Zoom talk over, sorry.
My response is only concerning her proposed order, right?
Yes, yeah. If you feel that she got it right, then you don't need to submit anything. If you feel that there's some error or it's not exactly right, then you would file something, say, hey, this is where she didn't get it quite right of what the court ordered.
Okay.
Okay.
That should give me adequate time. Thank you, Your Honor.
Okay. All right. Great. All right. So I think that covers the issues. Thank you, everybody, for your input. I appreciate that. If there's no other issues, we'll adjourn and we'll see everyone on December 29th at 8:45.
Thank you, Your Honor.
For today, and that's the BOP or the Graunitz and BOP matter. And I see Mr. Bop's present, Ms. Winkles is present, and then I see that Jacob is present. And I'm not sure if you're in the right courtroom, Jacob, or if there's another one that you're looking for.
I think I'm looking for another one, sir. I seen your name and I was supposed to meet with you today at 8:45, and so I guess I'm at the wrong room.
Yeah. Let's double check. Remind me of your last name. I remember seeing you recently.
Giese.
That's right, guys. That's right. Yeah, I'm showing that it's scheduled for next Friday at 8:45. That's when the presentation docket is for next week.
I got the dates mixed up, and I appreciate you, sir.
Better to be early than late.
Thank you.
Okay. All right. Thank you.
Bye.
All right. So, Ms. Winkles, can you hear me okay?
I can. I hope you can hear me. I'm having internet issues.
Yes, I can hear you just fine. And Mr. Bob, can you hear me all right? Okay, great. All right. So we're here today for presentation. I received a proposed order granting partial summary judgment, and I also received from Ms. Winkles the objections or concerns raised by Ms. Graunitz via email. So thank you for forwarding that to me. Have you had any contact with Ms. Graunitz this morning or recently about whether she's planning to attend today?
No, I have not.
Okay. All right. So Ms. Graunitz raised three issues. One, she believes that the commencement of the cohabitation should be March of 2018. The evidence at the trial and my finding was that it was mid 2018, so mid is June. So I'm going to leave it as June 2018. She also raised issues of the sauna and the 1969 Ford, that should be involved in the property distribution in some way. However, to my recollection, there was no evidence produced at trial regarding the sauna nor the Ford. So I'm not going to include the sauna nor the Ford in the distribution order. She raises a third issue as far as some additional tools from 2018. I believe that they should have been included as separate property. The court ordered Mr. Bop's list of property. I think that was Exhibit F. So that remains unrebutted, and there wasn't any evidence to the contrary. And there is Ms. Graunitz now. So.
Yes, Your Honor.
All right. Good morning to you. On the line with us, we have Mr. Bop and Ms. Winkles. I had we started at 8:45, so I was just going over a few things. And so I'll rehearse everything that I said in your absence. So we're here today for a presentation for the order that grants partial summary judgment. I received a proposed order from Ms. Winkles, and I also received your concerns or objections to that order that Ms. Winkles forwarded to the court via basically a copy of your email. So just want to go through those objections and the concerns that you raised in your email. So the first item that I noted was that you felt that the cohabitation start date should be March of 2018. In the trial, the evidence that was produced was mid 2018 as the start date, and I think there's even some testimony related to June. Nonetheless, that's my ruling that it's June of 2018. That's the start date of the cohabitation. The next issue is the sauna and the 1969 Ford. that was an indication that that was those two items were purchased in 2018, early 2018. At trial, I don't recall any evidence related to the sauna nor the 1969 Ford, and I just want to double check with Ms. Graunitz if it's your recollection that there was or was not any information related to that raised at trial or during the trial.
I don't believe those two items were brought up in trial. I brought those up separate from the trial discussion.
Okay, all right. So since the well, I say trial, I should say summary judgment motion. So since this order is based on what was produced during that hearing, I'm not going to make any adjustments to include the sauna nor the Ford in the ruling. So since there was nothing proposed during that hearing, I'm not including the sauna nor the Ford in my ruling. So then the third item that Ms. Graunitz raised were some tools on the Coal Creek residence related to those that they were purchased. So it sounds like that was a request to include those as Ms. Graunitz's separate property, or that they should somehow be included in the distribution of properties. So at the motion, I adopted Mr. Bopp's list of property that he presented because there was no additional rebuttal evidence to those tools. So I'm leaving that as is as the Exhibit F, basically is the listing of the property that I'm adopting. So one thing I wanted to just mention, Ms. Winkles, is that in your proposed order, it mentions Exhibit F. And I'm not sure if it was your intent to include and attach Exhibit F to the proposed order.
It was.
Okay. Is that something that you could forward to me so
Yes.
I can attach it?
Yes, it should have been attached. My apologies that it wasn't.
Okay, great. I'll look forward to that. Will you be sending that via email?
Yes, we can send it via email. Absolutely.
Okay, great. So once I have that, I can file that, attach it to the order, sign up on the order, and then submit it for the clerk for filing. I want to double check with Ms. Graunitz. Ms. Graunitz, do you have any additional items that I may have missed in that email that you sent to Ms. Winkles?
I apologize. What do you mean? Do I have any additional items to contest or to add, or?
Yeah, good. Yeah, thank you for the opportunity to clarify that. So we're here for a presentation, basically a summary order of what the court ruled at the motion for partial summary judgment. So I have that proposed order, and I reviewed your email to Ms. Winkles, which I consider some of your objections or concerns related to that proposed order. So are there any other items that you feel that Ms. Winkles did not get right or did not include in the order for partial summary judgment?
I don't believe so. As I stated previously, I'm not contesting the items, and I want to make a note that the items that were on the tools on Exhibit F are now in Mr. Bopp's possession. I'm needing to calculate my losses, so I am looking at what I would have had I not been cut out of this 5-year partnership. So as far as the tools and the property go, we're just putting it on the record. He's got possession. He's going to maintain possession. We're not arguing over the stuff. I don't want any of this stuff. I just need paid back. So I believe that we're in good shape. I don't think there's anything for me to contest, but I wasn't interested in contesting the objects to begin with. So.
Okay. All right. Well, thank you for that input, Ms. Graunitz. I'll once I receive the Exhibit F from Ms. Winkles, I'll attach it to the order that was proposed. I'll sign off on that order and submit it to the clerk for filing. So I think that concludes our activities for this morning on the presentation docket. Ms. Winkles, any final items?
No, Your Honor. My apologies for that not being attached. We'll send that to you ASAP, and we'll include Ms. Graunitz on the email.
Thank you. Ms. Graunitz, any final items?
May I ask? I'm sorry.
Yeah, go ahead.
there's an affidavit of destruction I keep seeing on my case files, but I haven't seen that. Could I get, is that the same affidavits, or are there multiple affidavits floating around? I'd just like to request those. I'm seeing them online, but I haven't received them in my the mail. Or
So tell me what you're looking for.
the when I go on my caseloads, or yeah, there's the council, or there's an affidavit of destruction listed, and I don't have that in my files of information.
Okay, I think I know what you're talking about. There on December 20th, there was or the 22nd, a document was filed. The title of it is Stipulation or an Order for Return or Destruction of Exhibits. That's the document you're referring to?
I don't know. I just, on 1108 and 1226, both, there's different affidavits of destruction on them that I'm seeing. But if I could just request a copy of those, that'd be great.
Yeah. So what I would encourage you to do as an option, you could check with the clerk's office and they could help you with obtaining copies of that, either through Odyssey or getting a copy from them. Because I do see the one order, there's a stipulation and order for return or destruction of exhibits that was filed on the 22nd of December, which says that it's stipulated between the parties. Oh wait, actually that's 1222. Looks like that's, sorry, let me get to the right case file. I was looking at a different one. I apologize. One moment. Oh, okay. Yeah, the clerk was just sharing with me that there was, it looks like the clerk's office made efforts to contact Ms. Graunitz related to some exhibits. They were unsuccessful in getting contact from Ms. Graunitz, and so they indicated that if they didn't receive contact on it by a certain date, then they would be destroying those particular documents. So that's what you're talking about, correct, Ms. Graunitz?
If that's what you see, all I see is it says that there's an affidavit and then of destruction, and that's all that's all it tells me. So if that's what you're seeing, they have contacted me. There was the wrong cause number or case number on one of the files. So if that's what you believe it to be, that could be the case. I didn't know if there was other declarations or, but if that's something from the clerk's office, and that would explain why I don't have it. So if that's what that means, I'll just know that that's what that means. But
yeah. And maybe what you could do is that I'm showing 3 documents. I did just a keyword search under affidavit for destruction. I pulled up 3. One is from November 8th. That's an affidavit related to an affidavit of destruction. And then there's a December 26th affidavit of destruction. And then there's also a second affidavit of destruction on December 26th. So what I would recommend is just, you could call the clerk's office. They could explain what those documents are. And if you need a copy, they could arrange to get copies to you.
Great. Thank you. I should have a courier available today. Okay. Thank you for that information. I appreciate that.
Okay. All right. Very good. All right. Thanks. So with that, that ends our discussion of the presentation. So thanks everybody. Happy New Year and safe travels if you're out and about.
Thank you, Your Honor.
Thank you, Your Honor. Happy